Welcome, friends, to Investment Immigration Conversations. I'm your host, as ever, Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. Wow. Let's all take a breath. There's a lot going on everywhere, and no less in our EB-5 space. And it is all going to be okay. I promise. So we are here to talk about regional center compliance. Of course, the EB-5 reform and Integrity Act of 2022 was all about bringing regional centers into their next iteration under the new law, which is focused on bringing reform and additional oversight and additional administrative burdens and costs to regional center operations. And there are a number of annual obligations as well. So we're going to hit on some, if not all, if not most of them, and talk about the state of play, what we know and what we don't know. And there's a lot of that. So as you know, I like to kind of just talk, but I think it's important to be precise here with exactly what we know, what we think we know, and what we really don't know. So once again, I'm going to turn to the aid of slides. So this is a little bit different. So let me do this. And I might even pop in and out of slides and point to some websites as well, particularly USCIS websites, which have been so helpful. Oh, there's already a hand raised. So let me just make sure that my sound is on. Somebody telling me that my sound isn't on. That's not good. All right. Okay. So I'm going to assume that everybody can hear me and just start. Okay. All right. So again, we're talking about the RIA and regional center compliance. And I'm going to disclaim everything. I'm going to disclaim timeframes, estimates, statistics, any kind of future gazing, because there's a lot of unknowns, perhaps too many. Okay, so let's hit integrity fees first. And I will say that if you really kind of dig into this, this is probably the most confusing. But I will also say that I think this is the area where there's the greatest of clarities. Okay. All right. So very recently, September 29th, we got an alert from USCIS, and the link is right there. Definitely go to the USCIS website, do a Google search on these alerts. They are chock full of information. Not answering all the questions we have, but we want to start with the information that the agency has made publicly available. And so there is a recent USCIS alert on integrity fees. Not wanting to stop there, if you have questions, and you very well might, you will want to go to the Federal Register notice that was published last March, which has a lot of language, a lot of detail, a lot of reasoning behind USCIS's deadlines and how it is implementing the RIA's requirement to collect integrity fees from regional centers. I say that I think that this area is probably the most confusing because, first of all, the iterative deadlines, but I think it's really about when they are due, because in almost everything else, we start after the end of the fiscal year, right? So for annual regional center certifications, the 924As and now the 956G filings, we wait until the end of the fiscal year, and then we have about 90 days to submit the annual certification for the preceding fiscal year. With integrity fees, we pay in advance. So right now, we are actually past the due date for fiscal 2024 integrity fees, because the RIA requires integrity fees to be paid at the start of the fiscal year. So we are now in fiscal 2024, starting October 1, 2023, and ending September 30, 2024. So we're in fiscal 2024. And the integrity fees are due October 1 of the fiscal year. So they were already due. However, we have 30 days to pay that integrity fee for fiscal 2024. So you have until October 31 to pay. I will recommend that you do go to my announcement or the news article that I wrote about the integrity fees right here, because there I point to where you can go to pay the integrity fee. So you go to pay.gov, and then from pay.gov, you navigate to a particular area for EB-5 integrity fees. And if you, that article has the links. Now, what about fiscal 2023, last year? So the announcement covers fiscal 2023 integrity fees as well. So this was also the confusing part, right? You know, those moving deadlines, because under the RIA, they were due October 1, 2022. And that was just a few months after the RIA had passed. And so the service extended that deadline to March, and then gave it 30 days from there, which took us to April, and then extended it again to May. So this September 29, 2023 alert appears also to extend the deadline for fiscal 2023 integrity fees as well, for those who haven't paid, understandably, because it was so confusing. And the notice nicely acknowledges how confusing it all has been. And so it refers to an October 1, 2023 deadline to pay fiscal 2023 integrity fees. However, it's, you know, we have a 30-day grace period, if you will, to pay the integrity fees that are due October 1. So we're making October 1 the due date for fiscal 2023. You know, I want to say that there's at least a good argument that fiscal 2023 integrity fees can be paid up to October 31, 2023. So if you haven't paid for fiscal 2023 yet, and you want to, I think you want to pay fiscal 2023 integrity fees as well. Now, there are consequences stated in this notice for failure to pay by the end of December. So the notice says if there is, for all regional centers that fail to pay the integrity fee, okay, by December 30 of 2023, USCIS will take action to begin termination proceedings. Yikes. So if you do not want to be terminated, take action to pay the integrity fees, certainly for fiscal 2024. And if you haven't paid for 2023, pay them now for fiscal 2023 before December 30th. Integrity fees. All right. Sustainment guidance. On October 11, USCIS issued another alert, and this time about two big issues: sustainment and subparagraph M, protections for good faith investors associated with terminated regional centers and debarred new commercial enterprises. So the bigger of the two news items is certainly the sustainment announcement. So under this announcement, the pre-RIA investors' sustainment policy, the sustainment period, doesn't change. It's still the old 2 years of conditional residency, the famous footnote 4 under chapter 4 of the policy manual governing regional centers and EB-5 investments. Post-RIA investors, completely different new rule. The required investment period for post-RIA investors is 2 years from the time of investment. Front end, not the back end. And the alert goes on to say it's 2 years from the time of the required investment. So presumably it means if you're in the process of investing, it's not from the date of your first tranche, it's from the date of your completed tranche, your last tranche. Also, it's post-job creation. So if there hasn't yet been completed job creation, then it's not 2 years from the time of investment. It's a period after that, after there's been job creation. And the USCIS EB-5 FAQs or Q&As actually goes into that a little bit, which we'll touch on in a moment. Very, very important public guidance from USCIS about RIA implementation, particularly affecting regional centers. We'll get to that in the next slide. So two different treatments. It also says that in order to help the service evaluate eligibility under its new interpretation of the investment and sustainment requirement, it is requiring that the investments be in place at the time of filing as well, because we can contemplate a situation where it's been 2 years since the completed investment was made, and then there's the 526 or the 526E filing. So the question is, do I need to have kept the investment in, even though it's after 2 years at the time that I file my 526 or 526E? And the answer is yes. Yes, you must. Obviously, a lot of questions here. Almost immediately, investor clients were asking, what does this mean? Does this change anything? What are the regional centers that I'm considering investing into? What's their position on this? What are they doing? And the answer so far for projects that are already out there and taking investors appears to be not anything different. And that makes sense because these deals are already inked. They're done. They're not going to go back to the borrowers and say, there's been a midstream policy change, and can we make our 5 and 1 + 1 or 7-year deal a 2-year deal now? That's not going to happen. So the projects that are already out and marketing and recruiting investors, I would say very unlikely for there to be any shift there. And also, this is brand new. It is unclear whether or not this will remain policy. So, may not make sense along that dimension as well to try to go back and re-ink deals. However, going forward, particularly if this policy looks like it's going to stay, and that's an if, I can certainly imagine deals, projects that are that have a shorter structure to accommodate or to take advantage of this new policy. A lot there. Okay, so what about the subparagraph M portion of this, the good faith investor provisions? So by way of background, one of my favorite things to talk about, this is a brand new, unprecedented area introduced in the RIA, adding the new subparagraph M as in Mary to 203B5 as amended by the RIA. And what subparagraph M does is it brings in provisions, mechanisms to protect the investment process, and really has some, expansive ameliorative provisions as well to make things better, to make things easier, and also good things. I call it sort of the basket of goodies, like priority date protection, age out protection for kids, and so forth. Insulation from material change and all of that. So this policy alert seeks to at least start the conversation on answering some of the questions. For example, does this apply to pre-RIA investors? The answer is yes, which is very nice. And I would say that is 100% consistent with what I believe to be the intent when this subparagraph was drafted. So that's very, very good. And there's other language. It's sort of difficult to know exactly how it would be implemented and how it would be operated on the ground. And those are very fair questions. And we need elaboration of this guidance to really kind of get a feel for that. But another aspect of this announcement is, so the RIA calls for 180 days, during which time affected investors of terminated regional centers and debarred new commercial enterprises would have to file an amendment with USCIS and to say, look, I know my regional center was terminated or my NCE was debarred, but I still meet eligibility requirements. I still have, still sustaining my investment, although now that period appears to have been changed by policy, and I've created, my capital has created the jobs. And so my immigration can proceed, and I have these other protections. And the service in this announcement is saying, we can be flexible with that, with 180 days. We can give you until we actually get to your petition. So that's really good. These are good signals. Of course, it is also reserving room to say, if there are situations, if we encounter fact patterns that we don't like, then those flexibilities could be off the table as well. Not entirely unreasonable, right? But of course, folks are going to say, we've got to see how this is actually going to be implemented on the ground. And with that, I agree. So bottom line, bifurcation of pre-RIA and post-RIA investor sustainment periods, clear. 2 years after full investment and job creation for post-RIA investors. And it's signaling helpful interpretation of subparagraph M for good faith investors. That's good news. All right, 956, the 956G. Now the first bullet point here, USCIS EB-5 Q&A, updated last October 11. This seems to be a day that was an eventful day. This is very, very important, and I commend everybody to study this. This has really become like the thing that you print out and refer to again and again, many times in the course of your day. And this answers many, many, many questions about the order of filings. What's got to happen first? Does the 956 have to be filed? Does the 956F have to be filed? Yes. And then the 526E. Does the 956F have to be approved before the 526E is approved? Yes. And a lot of other questions are addressed in this Q&A. So it really has become another source of guidance. So I would say at this point, we have the USCIS policy manual, right? volume 6, part G, and it's got the chapters that break down eligibility requirements, petitions, removal of conditions, deference, policy. Notably, within that table of contents, chapter 3, where regional center guidance is reserved. We don't have regional center guidance in the policy manual implementing the RIA, although the other sections, I must commend the agency for filling out very nicely in guiding petitioners, okay, investor cases, even having, sort of pre-RIA and post-RIA, pre-March 15, 2022, post kind of guidance, so we can refer to, well, what applies to whom. Regional center guidance, we don't have the policy manual. We have the law, we have the statute, 203B5 as amended, and other areas of the INA amended by the RIA. So for example, 245N, as in Nancy, dealing with concurrent adjustment of status filings. So we've got the USCIS policy manual. We have the bearing settlement agreement, to which I have the link right here. I think, as I've said before, this is a must read for EB-5 citizens. And now we have the USCIS EB-5 Q&A, which is really not comprehensive, but covers a ton of ground. So I pointed here to an article that I wrote some months ago, kind of breaking down where we are with the bearing settlement. And I thought this was important because it is so important. It is still governing our ecosystem. And I think it's important to get a feel for that, understand the mechanics of the settlement agreement, particularly in light of the guidance that's come down in the last few weeks about integrity fees, about 9.5 of the Q&As covering the 956 and the 956 Gs. One of the most important principles that all of these elements touch on is the service's position that the RIA covers all regional centers. It covers pre-RIA regional centers, and it covers RIA regional centers. But what about the 956? We don't yet have a deadline for the 956. The original deadline for filing the 956 for regional centers seeking to continue to operate under the RIA, sponsor new projects, take in RIA investors, that deadline was originally December 2022. That's been pushed out, but we don't have a deadline yet. So as of this moment, if you are a regional center designated before the RIA, but you have not yet filed the 956, you are still designated. And therefore, according to USCIS's written guidance so far, you are governed by the RIA, regardless of whether you file the 956 or not. So all of the integrity provisions apply. Now, what if I a regional center, do not wish to continue to operate under the RIA? I'm not going to launch new projects. I'm not going to take in new investors. Do I have to file the 956? Well, the settlement agreement says you only have to file the 956 if you have the intent to continue to operate under the RIA. So the obverse, if you do not, then you may not. What are the consequences? Termination, I would say. I don't know if I've seen any written statement so boldly concluding that a failure to file a 956 will result in termination, but that is the natural conclusion. The RIA applies to everybody. The settlement says to continue to operate, you've got to file a 956 whenever that is due. If you don't file a 956, you will be terminated. Again, that has not been expressly stated as far as I know, but I believe that is the natural conclusion to the story of the 956. What about the 956G? I think we have even less clarity on this, but I think the logic is the same. And this is the position that I took in the very beginning. If a regional center is not going to operate under the RIA, not going to sponsor new projects, not have new investors, is it going to be required to continue to file the 956G? If you don't file the 956G, again, since all regional centers come under the regulatory umbrella of the RIA, what will happen? Termination. Failure to file the 956G will most likely result in termination, although, again, I have not seen anything written that states the consequence as such. Could a regional center elect to file the 956G? I think that's a very interesting question. And I think it's a question worth asking. And I don't have a clear sense of what the right answer here ought to be. The investors, we've got to look at this from the investors' perspective. We know from as much as we can know anything, I suppose, from the settlement agreement, that even if a regional center is terminated, the investors' cases will go forward. It'll go forward. The settlement agreement says it will, that failure to file a 956, for example, by itself will not be a reason to deny an investor case. And we have the grandfathering provisions of subparagraph S, S as in Sam, under the amended 203B5 as well. So good momentum behind the conclusion that even if a regional center is terminated, the investors' petitions will go forward. And we have the umbrella of subparagraph M for terminated regional centers as well. So I think that is where we are on 956s and 956Gs. Still not clarity in, sort of stark black and white, do this and then X, don't do that, then Y. It feels like we are getting there. It's very clear for regional centers wanting to continue to operate. They've filed in the 956, file a 956G, launch their 956Fs, right? It's really for the other regional centers, right, who are who don't have the intention to continue to operate under the RIA. What ought they do with their 956s and 956Gs? Bottom line, no deadline yet on either of these filings. Retiring regional centers may not need to file the 956 if no RIA investors, but still, no answer on the G. I would say in terms of the hierarchy of opacity, I think we're closer to getting clarity on the 956. We're further away from the G because even if a regional center is not going to operate under the RIA, they might still need to, or it might be prudential, it might be optional. I don't know how this is going to go, but there is some logic to a continued G filing, because it could be helpful to the service as well to kind of have a filing that categorizes all of the investors associated with it, even though logically that may not be sort of fit neatly within the RIA framework for regional centers that are terminated. And so, which leads to an interesting question. So it would be very nice to have all of that data captured in a neat 956G filing. But then would a regional center also be required to pay the integrity fee? Unanswered. Okay. They must also file the integrity fee until terminated. Yeah. So unless you're okay being terminated, got to file the integrity fee. That is clear. Cool. All right. So got a few questions. Gonna take a few and then we'll cut for the day. All right. Will it affect the 829 sustainment? Yes. Oh, yes. Indeed, it does. The new sustainment policy. Yes. And that is, it's discussed in the Q&As as well. So, and this was the basis, one of the legal bases behind the services interpretation that the investment period is only 2 years, because we used to have language in the 216A, the law of removal of conditions, that said the investor has to be substantially sustaining the investment. That is gone, and so the service pointed to that, and new language in A, 203B5A, that said the investment period is expected to be 2 years for its conclusion that it's now a 2-year period. So yes. That's the interpretation announced on October 11. Again, pre-RIA investors, they are explicitly under the RIA's 216A. All of the pre-RIA investors, 829s, are governed by the old 216A, the law that was in place when their 526 was filed. So they are definitely governed by the rubric of sustainment until the end of the conditional residency period. Although, that is, I would say, that's not entirely black and white either, from a statutory construction standpoint. Do you agree the pre-RIA investors in terminated regional centers now forced to reaffiliate with RCs even during conditional permanent residency, considering that pre-RIA policy protected from termination CPR? Very interesting. Okay, so let's unpack this. Lou, do you agree that pre-RIA investors in terminated regional centers are now forced to reaffiliate with regional centers even during conditional permanent residency, considering that pre-RIA policy protected those investors from termination, from being associated with the terminated regional center? That is a very astute question. Well, let's try to be logical about this. So we have subparagraph M applying to the pre-RIA investors. Now, the pre-RIA, everybody will have the opportunity to say, even though, just my luck, I am associated with a terminated regional center or debarred NCE, I can still establish my eligibility. I can still tell you, I've created the jobs. I have sustained my investment over the required period. And so please approve my immigration petitions. I mean, I think that, and the question is, would they be required to reaffiliate for that purpose? I'm going to have to look at subparagraph M. But I don't know. I mean, they shouldn't have to, right? Because they're establishing eligibility, notwithstanding the regional center and the new commercial enterprise. Yeah, I mean, that should be the right result, that they should not have to reaffiliate if they can establish eligibility. Particularly if they've completed job creation and don't need to have that structure. But I'm going to look at subparagraph M again. Thank you for that question. Termination during CPR. Yep, I knew what you meant. Boo to USCIS on the policy manual. They have neglected to update the 526 and 829 chapters as well. There's some in the 526 sections, right? Yeah, there's like the whole, like for example, TEA on redeployment. So yeah, it's a Herculean task, right? I mean, I think we need engagement. We need substantive engagement. Obviously, that is to the good of everybody. But there's a lot to do. A lot's been done as well. A lot more needs to be done. Okay, now the RC has to report all sponsored. Okay, I'm gonna put on my reading glasses. Now the RC has to report all sponsored projects with a 956G. What happens to those projects that the RC chooses not to report? Are they now considered unaffiliated? Wait, I don't know. So chooses not to report. You can't pick and choose not to report, because there are penalties for failure to include everything you're supposed to, in your certification, right? I mean, now we have penalties. Chooses not to report. Are they now considered unaffiliated with an RC and then can look for another new affiliation based on spirit of the RIA? So if we're talking about subparagraph M remedies, if we're talking about NCEs, good faith NCEs, if you will, affiliated with a failing or terminated regional center, then they can unhook, right, with the terminated regional center and rehook with a regional center in good standing. So that regional center that's been terminated, presumably would not have to file a 956G. I don't see a logic for a terminated regional center filing a 956G again, which is why I think, I see that it could be beneficial. So they'd have to kind of like shoehorn that logic in somehow. So presumably, no 956G at all for terminated regional centers. And then the reporting for the regional center that is now hosting this, reattaching new commercial enterprise. Yeah, I think it would have to be included in the G reporting, in that addendum. Yeah. Wonderful. Did I get everybody so far? Okay, great. I truly did not intend to go on and on. There's a lot to say. I wanted to share some resources, some of my thinking at the moment, and I invite further conversation. Thank you, everybody, and we will see you next time. We're going to keep doing this. We've got more events coming up throughout November and December. December is something I look forward to when I look back on the year in EB-5 and do the annual EB-5 retrospective in December. So look for that. And it just occurred to me, if there is a speaker you would like to see in our conversations, write it in. Contact at Carolyn Lee Pllc, and we will try to get that individual to join us on our retrospective. Thank you so much. Be well, everybody.